It started, yes, so it's recording now. Okay, so yeah, this is the book I will be talking about right now that Aya so wonderfully introduced, and I want to start by sharing a little bit of how I got to the questions that the book talks about. So the book is called Refugees, Democracy and the Law. But really where I came from was an interest in this question of migration and law. So I want to say a little bit that what I will explain more when I talk about these chapters, really the interest in the refugee doesn't mean so much the interest in the refugee as a completely separate category, different from other areas of migration or other groups of migration. But it is really an interest that comes from a certain it comes from my legal view on those norms, but it also comes from an understanding of how the refugee concept plays in. So the question I came from was really a legal theory interest in the interrelations of migration and citizenship. I look at them as some in a mutual dependency, in the sense that whatever happens with migration is very much framed by law, by regulations. I think this was in the short introduction that Eyal read, that there are all those laws that govern how we are mobile or not, and to all of us, regardless of what kind of migration we want to enjoy. And so on the one hand, law governs migration, and it's very much through citizenship as the basis of legitimate laws, as the basis of how laws are made, that migration is determined. On the other hand, migration will also influence who in future belongs to the citizenry. Even though migration at first, and many kinds of migration, are not geared towards the durable stay in the country. Many people will come maybe as tourism, that's also migration, or they will come for a few years working and return. But potentially in our system of a territorial state, the presence that migration entails also means that people have eventually, under further conditions, but have access to political membership. And so in that sense, migration always also concerns the very basis of future citizen decisions, of future political equality. And I think this explains, as one aspect, why migration is such a very contested issue in politics also nowadays. So there is this mutual dependency of migration, citizenship, and this has led to many legal theory, political theory questions about migration, about how can border laws be legitimate? What political theorists often call the boundary problem. How can democratic decisions be made about laws that concern entry when only one side ultimately decides, when the people who are still outside can never have a say in those decisions? That's one way of looking at it. The other is to ask how can this asymmetry be negotiated? So are there any rights really to enter? And that's where the refugee concept is somehow specific when we look at it from a legal standpoint, where the one exception in an overall system where states have free decisions, can make absolutely arbitrary decisions if they want. They can govern all rules on who can immigrate into a country, except for certain rules of international law regarding human rights, but initially with this figure of the refugee, certain people in under conditions of hardship, and we'll talk more about this, have actually a claim towards the state. So there is something specific in thinking about those larger theoretical questions that then appears in a new light when we look at refugees, because they're the one category of people who have a right to migrate to some extent. So at this point, let me start sharing my screen to give you at least a bit of an overview. Should start. So, oops. How can I go forward? Excuse me. This is just the book, the cover. This is the table of content, but this is where I'm at with talking to you about the question that motivated me. So migration, democracy, that was the starting point, and then the specific position of the refugee concept in this, what I call the legitimacy framework of the territorial democratic state, where this is not just an arbitrariness in the sense of a lack of governance or a lack of democracy, but very much how the modern state is understood, that rules are made by citizens of a state. So it is legitimate that they are kind of made regarding migration unilaterally. But there's also this idea of the refugee as a category of exception. And what is interesting is that it's not so much an abstract claim to exclusion, but a concrete claim. So it's attached to a particular situation where a person is in need of protection or under conditions of hardship. And I contrast this a little bit with a strand of political philosophy that speaks about duties towards strangers, or that operates on a very abstract level of what's being called cosmopolitan duties or moral obligations toward refugees. And while this is a very related field of scholarship to the interests I have, I've been interested more in, coming from a legal background, I've been interested in not how we juxtapose the world as it is with a world as it should be, but rather where are the little lines where those claims are negotiated. So that's what got me interested in those moments of negotiation around the refugee concept. And ultimately, as sort of the background question that is in my head during the whole book is, what can we learn more generally beyond the refugee situation, but also beyond migration specifically, from those contestations around refugees' political voices, about migration, about democracy and citizenship in times of globalization? Because I think there's something parallel in the questions that we see regarding refugees' migration, where the regular institutions, the regular procedures of democratic participation do not really fit. And we are, at the same time, everybody has these questions of how, in a world that is more and more moving away from only state level governance to more international governance, how for those international modes there can still be meaningful democratic participation. So I think there are some aspects where we can learn from those contestations around refugees' political rights. So very basically, the structure of the book is this one that you see. So it has two chapters: the refugee, that talks about the refugee concept and the legal definition of the refugee. Then it has a second part that I've called Democracy's Edges, that speaks about citizenship and democracy respectively, with a view to the margins, to the edges, how being a citizen, how participating in democracy is negotiated. This is the second part, and this kind of establishes a vocabulary to then, in the third part, look at the legal conditions of refugees' political voices. So in different sides, I look at how this question, how can refugees have any meaningful way of participating in political decisions? How are those questions negotiated in different sides? You'll probably wonder, and hopefully better understand once I get to those chapters. Before I delve into this first part, let me maybe share a little bit. I think the first question that comes up, specifically, some of you might have worked in the area of migration, many of you probably have worked. One question that might come up is really, why democratic rights, or why political rights? Isn't this sort of a luxury question when we talk about refugees' rights? There are so fundamental challenges regarding the refugee situation that political rights are really the last we worry about, you might say. And I think one claim I make also after having worked on this book is that this is by no way marginal. It's not secondary or a luxury question, but it's very fundamental for understanding how refugees' rights are effective or not. And I think the whole debate that has unfolded around Hannah Arendt's expression of the right to have rights is kind of a gateway of understanding this dependency of political standing, of political rights and rights protection more generally. And I'll come to that. But so this is just the first address, and maybe you have a question about this. I'd be happy to discuss this later. Like, why political rights? And then the other one that kind of keeps training in my mind is how can we think about the specific situation of the refugee that is that's a small group within migrants today, and apply it beyond this group, or how to think about those categories in relation. And I'll enter the first part now, but just to emphasize again, I don't think of these as essentially different categories. I don't think of this as there's any truth to who's really a refugee and who is not a real refugee. I think of it more as analytical categories or legal categories we have to work with, that are also given tools to look at the world, but that ultimately are always in negotiation. And it's those very negotiations are also between the categories that are at stake when those political rights are discussed. So to start a little bit, and this is core to kind of the way I approach the topic, the question, who is a refugee? What is this refugee concept? And the claim I make in this first chapter, or that I base the book on, is that there's something we can call a normative idea in the refugee, that the refugee concept embodies, that means it's normative, but it's more than just the legal definition. And when you think of just the last years, how much contestations there have been around the use of the refugee notion, this is in some way very illustrative to that claim, that very often you will hear people say, well, those are not real refugees, or you'll see people protesting with signs, we are refugees. And in all these talks, kind of notice that this seems to be about more than a legal definition. You maybe in the case of protesting with the sign, you could say, well, this is the sign saying we fit the category of the refugee convention, maybe. If you say not a real refugee, why would you contest? I mean, you have a procedure to determine who is a refugee or not in the legal sense, but there's something more. There's this idea that being a refugee means making a legitimate claim. And I think it helps understanding how we today have this sense that the notion of refugee is more than just a legal concept, by looking a little bit at the history of how the refugee concept developed. So the notion in English, the term refugee in English comes up in 17th century, slightly after the French term réfugié. And so the Huguenots fleeing France often are referred to as the first refugees in this sense. But what I find interesting is that this is a time where the political order in Europe, so where this term emerges, is changing fundamentally. So we often speak of 1648 as sort of the birth date of a territorial order of state. Of course, that's not something so momentous. It's not in one moment that the political order changes, but there are changes over those decades or in this century that really move towards a territorial order, in the sense that territorial borders also become more relevant, more important. And what the refugee concept does in this situation, in a way, is it offers a reason, or the concept contains a reason why, or a description why people are migrating. It introduces a differentiation in the sense of migrating for hardship. A refugee is someone, in a very broad sense, who is migrating for reasons of hardship or forcibly. And this distinction, or this information in the term, makes sense under a condition where there are where reasons are asked for migrating. So you can say you don't really need a explanation in a system where you can always settle anywhere. So it is in those centuries, and this incremental development, that there's more importance, or more also political thought developing about the question, who can enter? What are the conditions of entering a country? Whereas before, freedom of movement was discussed along very different lines. And also entry into community was less discussed in this territorial sense. And what we see in this political thought of the time is an idea of an exception. Generally, this order or this legitimacy thinking of the time is marked by attention. It has, on the one hand, at its basis, this universalist ideas of human freedom and equality that you see in the French Revolution, but I think that's to some extent inherent in also the territorial idea that kind of saying everybody who's here, so everybody who is around you, is politically equal. Of course, this comes with many buts. Women were not equal, minorities were not, so there was a lot of exclusions. Still, there was a universalist idea that during those century also provided an engine for all the future political developments in the state. At the same time, this universalist ideas were very sharply delimited by territorial boundaries. It was an idea where if you're in the state, you have rights. If you're outside the state, you don't. Also duties. So there was a territorial delimitation that can easily seem arbitrary. Why would you have right if you're standing here and one street further, you have no rights? So in order to counterbalance this sharp or this arbitrariness, or also this tension between the universalism on the one hand and this delimitation on the other, the refugee or this normative idea of a right to entry really provides a counterbalancing exception. It says, and there's this famous quote from Immanuel Kant, where the stranger may not be rejected if it cannot happen without his destruction. So under very specific circumstances, if someone is in immediate danger and at the border, he or she may not be rejected because this would mean risking their life. And this idea that under specific circumstances, there's a claim towards the state, really not just with Kant, with several thinkers of the time, develops as an idea of an exception. And Kant calls it the one cosmopolitan law. We can talk a lot about what this cosmopolitan would mean, but I think what's important about it is this idea that there's something very fundamental of a claim against the state or a claim towards the state. So whereas otherwise you could say, well, there's just no law outside the state because it's within the citizenry, within the political community that rules are made. This idea is somehow one that confronts the state from outside. So this is idea that is so fundamental because in our thinking, returning to the questions I started with in this mutual relation of migration and democracy, it almost works like a block in the door of saying, you can regulate all that you want, but there is a certain limit to the freedom to exclude, to the arbitrary decision of immigration laws, because there might be those claims from outside. Of course, at this point, this is not a legal claim in any way. It's a normative idea. And then the question is, how do these two relate, or how does this develop into a legal idea? And that's a little bit where the second chapter then follows, that, well, historically, with the start of 20th century, there is both a codification in domestic law, but also in international cooperation, very first roots of international cooperation on refugee protection. So it is during that time that the refugee concept really enters the legal vocabulary as a standard term. And it is the time where this idea of an exception kind of joins with the legal term refugee. And in this development, then on the one hand, it's an achievement that, well, it's a normative idea is a very weak thing in a way. You can't do anything with it if it's not respected. So in some ways, an achievement that this is entering the legal vocabulary, and then with the 1951 convention, fast forwarding several decades, actually enters international law as a solid claim. On the other hand, a process of legal codification, of course, also means by necessity, not even looking at the specific definition, it means by necessity a narrowing down, or it means that whenever you codify one case, you always leave out something. You never will have a rule that fits all potential circumstances. But so first of all, the refugee definition moves from a very broad but vague idea into something very concrete. I wouldn't read to you the Geneva Refugee Convention definition, but it has all those buts and ifs and extra exclusions and extra inclusions. So it's a very different thing, the legal definition, from a vague idea. Plus, there is a more general democratic theory question about this process of codification, because you might say, well, we were kind of talking about a claim towards the state from outside, but then any process of codification, whether it be in international law or in domestic law, again, is negotiated through the state structures. And even though there might be several states at the table, to some extent, one can say it's still from within the state, from within the states, that this codification takes place. And this is then, of course, not just on the level of a first written codification, but also on the level of application, that whenever the refugee concept is interpreted, whenever there are institutions that decide who is a refugee and who not, it is again in a very unilateral, and there's a certain unilateral fashion, there's a certain asymmetry. So the second chapter talks about this idea of a claim that initially is kind of outside a state order and then moves into the state order. And it ends with a reference to a political thinker that is very dear to my heart, Shalala Ben Habib, who's coined this notion of democratic iterations. So an idea that even though we might recognize, or we do recognize, that there is this unilateralness, there is this democratic asymmetry whenever law is made, there are also processes outside those strictly legal lawmaking processes, and there are public discourses that feed into the law, and the law, of course, also frames public discourses. So I think we can say this for the refugee concept, that while we have a codification now, we have different definitions also that should be said. For reasons of time, I won't go into this, but there are different competing definitions in international law, from the African Union Refugee Convention, from the Cartagena Declaration in South America or Latin America. So there are internationally competing ideas about refugee definitions, but also a broader discourse about who is a refugee or who has a legitimate claim to entry. So now I've spent a little too much time. Let me look at the clock. I've spent a little too much time on the first part, but I think this is important to see where I'm coming from when I discuss this. I'll try to be a bit quicker with the second and third. I'll be pretty quick on the second, because I think the third is really where we can speak more about specifics. So the second part mainly tries to give an idea, both for citizenship and for democracy, how there are those two sides. There's a side of legal status, of legal codification, of also the need for institutions, as I say, with view to democracy. And then there's a side where these are very dynamic concepts that are constantly under renegotiation. So for citizenship, and say, we talk about citizenship as an idea of active political membership. It's not just belonging in the sense of you're given the status and that's it. No, citizenship is about political membership, meaning participation. So there is an idea of citizenship that is sort of independent from the status you're given. At the same time, of course, it matters for your political influence, for your recognition as political equality, what legal status, whether as full citizenship or also as other political rights you have. And this is in this context of claiming rights important, as rights are often, again, in this mutual dependency of law and politics, that you're claiming rights, or you can claim rights even before you have them, only if you are given a minimum of political voice. And of course, legal rights will equip you and to give you entitlements to political participation. So this is chapter 3. Again, happy to talk more in the discussion. And chapter 4 turns kind of the view around from citizenship as an individual perspective of individual participation, whereas democracy is more the perspective of how to organize governance. And there again, I think we cannot understand democracy without those two sides. On the one hand, democracy has an inherent link to an idea of equality, of equal influence. You wouldn't say whatever is political organization and call democracy is democracy. No, there's an idea of inclusion, of non-domination. So you might say something is undemocratic. On the other hand, there is a necessity. It's not just in one instance political participation. There's a necessity for institutions that make political equality effective, that actually provide procedures for decision making, that provide institutions that ensure that there's equal influence. And between these institutions that, again, by necessity exclude or are incomplete, do not include everybody who might have a claim to participation, and these claims, there's a dynamic that there's been enormous scholarship on those questions of the boundaries of democracy, on also the question who's a subject of democracy. And that's a little bit what I try to talk about in this chapter, engaging also with all the scholarship that, or I'm not engaging with all that's been there, but trying to like situate my own reflections in what's been written by more intelligent people before. So with this vocabulary of citizenship democracy, the question I have in part 3 is really how in different sides the refugees' access to political voice is negotiated. And my thought is there that, again, there, of course, it's a mapping of very narrow spaces. So refugees, by definition, are not citizens. So they're not at the center of any political decision making. And you might even say, well, there's no, democracy is here and refugees are there. There's no access to political voice at all. But it's more complicated. It's a more gradual relation where there are situations, and there's also what's interesting to see in the law itself, a constant struggling with this question of how to include or whom to include in the decision making. And so what I'm looking at is, on the first level, what does the law regulate regarding refugees' political voice? But then also, how does the law regulate the conditions for outside the law politically participating, or outside the law claiming political rights? So when you think about protest, when you think about making your claims heard outside legal structures, again, the law, of course, is in many ways influential of how this can happen. So that's generally what I have in mind. And in chapter 5, I talk kind of starting from the institution sides, I talk about what does the law really say about refugees' inclusion. This is also a little bit how gateways to naturalization, to becoming full citizens are. There's also the broad discussion of partial voting rights that refugees as other migrants are given in some states after certain years. And then the third kind of area I look at is special bodies of representation that exist in some countries where they're either migrant councils or specifically for refugees. The idea that even though those might not be, have not full strong participation rights, like voting rights, they are bodies that political institutions refer to or ask for advice regarding migration decision, and this is an instrument of political inclusion. And chapter 6 moves a little bit to the level of not planned or officially channeled participation, but rather protest, any other forms of making your claims heard outside those procedures. And there, the associative rights, so the freedom of assembly and the freedom of association, are of primary importance. I talk a little bit about how those rights function, or how they are also extended to non-citizens, which is a question that differs from constitution to constitution a little bit. And then also how certain rules of refugee law affect the possibility to make use of those freedoms. So for instance, when refugee law, as it does in Germany, restricts the area in which refugees can move freely, this will very much affect the possibility to participate in associations, in assemblies. So this is chapter 6. Then chapter 7 talks about humanitarian government, meaning situations where refugees find themselves not in the I say regular channels of integration into a state, but rather instead in refugee camps, in other situations where UNHCR, the UN High Commissioner for Refugees, or other humanitarian organizations are their reference point rather than state authorities. And this is, I said, not the regular channel, but this is actually not such a small percentage of refugees worldwide who are in those situations of so-called humanitarian government, and who therefore, when thinking about the access to political membership, face different challenges. And the UNHCR has interestingly had several policies on participation in refugee camps, and kind of playing on an idea that this is a requirement. And I find it interesting to look at, because on the one hand, it reflects an inherent understanding that this is needed. On the other hand, there are many limits to what this can achieve. And my aim is also to situate it in this wider critique of humanitarian government that very often keeps people from also moving out of a refugee status after certain years. And then lastly, chapter 8 speaks about the international level, speaks about the question how it might be in international forums that there is some sort of representation of refugees. Very interestingly, the negotiations for the Global Compact on Refugees, so between 2016 and 2018, has been a time where this was at least rhetorically voiced a lot, where there was a lot of attention to, they're often called giving refugees a seat at the table or a voice to refugees. And you can hear from how I say that there is, of course, an element where this is at first mostly rhetorical, when we can ask if this is just window dressing, if this is of no actual relevance. I think it's not so easy to dismiss it completely, because again, it's important to see how from within the institutions there's a recognition that there's a lack of representation. At the same time, of course, this remains very preliminary. I use a little bit the differentiation between interest representation, opinion representation that Hannah Arendt also makes, to speak about how we can think about meaningful representation in those international forums. Again, this is more a very first idea, but I think also worth exploring, as this is such a fundamental gap in how those people most affected by the laws will have no say in their making. So this has been a very rough run through the book. In the outlook, I end sort of with two questions. One is to situate these very theoretical reflections a bit with the current challenges we are talking about in refugee law. Again, my understanding is that those political rights questions are very fundamental also to the overall situation. And I mean, from my personal experience, I can say that this book has been, I started my PhD, what the book is based on, in 2012. And then, of course, the years of 2015 and after very much changed the, well, certainly also the perception of scholarship in this field, but also the angle we, or I as scholar, look at those questions, in the sense that there was less questioning of its relevance, but also more, a much more politicized situation, plus a situation where very often I now more often find myself defending the law as it is, and calling for respect for the rules we have rather than so much criticizing the rules and talking about what we should have. So that's certainly a change, another change for the better that we've seen in the past years. So that's one area the outlook ends with. The other is really to pick up the question again, how is this relevant to wider questions of democracy in the times of globalization? And I think the most challenging theoretical question that my reflections come to is really this: does our political, not community, but our political processes end with co-presence ultimately, that always it's encounter or being present in one space where political rights and political mutuality emerges? Or is there anything of democracy beyond co-presence, of citizenship that is not between those who are co-present? And I don't have answers to neither of these questions, but again, also I'm very much looking forward to discuss some of all this with you. And thank you very much for your attention. I look forward to your questions.
Thank you very much. Thank you very much. It was amazing. Any questions somebody wants to raise? Yes, please.
Yes, I have a question, please.
Just quickly ask, should I turn on the recording now, or should I?
Yeah, you can keep it. It's okay.
Okay.
It's okay.
Okay. Do you hear me?
Pretty well, Avner.
Okay.
Yes.
Thank you, my best friend. First of all, thank you very much for the interesting presentation of your book and research. It's very impressive, Mrs. Schmalz, Dr. Schmalz. I have two questions. First of all, did you check that all the fragments of the refugees, what they present, it's all the same worldwide, or is just, can you divide different refugees on different parts of the world? And is it possible to do that? Because I believe that the refugees from different parts of the world are coming with different ideas, different mentality, different religion, and different ideology, and even different dreams. So I don't know, just from the research point of view, how did you manage to kind of put it together as an idea? And with your permission, Dr. Schmalz, I have another question regarding the negotiation that you have mentioned a few times during your lecture. And I'm just asking myself, to negotiate, you need two sides. Who represents the refugees? Thank you.
Thank you, Avner.
Should I answer right away, or would you like to?
Yeah, what is convenient for you?
Okay, yeah, I think this is, Lisa, two rather big questions, and I'll be glad to answer right away. So first of all, different refugees in different part of the world. You're absolutely right that, of course, the perspective I apply is at the outset a pretty formalist perspective, meaning that I do not make assumptions about how those people are that appear as refugees in a legal sense. But of course, those more material or more concrete political circumstances are ultimately very important. And I absolutely see the limits to such a formalist look at it. So that's the first point. Then, of course, it's not just the question of what cultural background, what assumption, what dreams, as you said, do people bring. But it is also in different part of the world, the different legal regimes, the different also political cultures that surround those. And this is a very interesting question. I mean, the different legal regimes, that's relatively easy to deal with, because I mostly look at, where I look at law, I look at either the international law that does or does not apply, but I only talk about Geneva Convention and so the international law. So you can already say there are states where this doesn't apply, fair enough. And sometimes I look at it comparatively, saying different regions, or even sometimes comparatively at constitutions. But again, so the legal side is relatively easy to handle because, again, this works with my formalism. then regarding political culture, it's very hard to make all those claims about democracy when at the same time, not every state in the world is democratic. And this is something that is also a real challenge to, I mentioned those UNHCR operations where you will have a refugee camp in a country which might or might not be democratic in the overall structure, but then suddenly you have a refugee camp that is led by an institution applying ideas not just of political participation, but very often UNHCR has, for instance, rules of gender parity, or all those assumptions about how politics should work. And I think this is a big question of how do we, on the one hand, also apply standards that we believe are sound and have reasonableness to them, but on the other hand, I think we must be wary of the whole question of also an imperialism of concept that we tend to see in those circumstances. So I hear your comments a bit in this direction, and I think this is a question I do not answer. It's a question that might well be asked also to the book, and I'm a bit, well, I restrain myself very much to looking at what I find in the rules, and I mean, very little entering the more the level of application to such an extent, where those material questions emerge more stringently, but I do see that this is a big question, for practice, but also for further scholarship. And then quickly, negotiation. Maybe I would like to hear also more how, and what you mean, because I do see that it's always a very unequal representation, because there's no unequal negotiation, because there's no representation of refugees. When I say negotiation, I have in mind that there are various instances where people will come and say, I'm a refugee. Maybe they will say it, maybe they will have an asylum claim. And then there are procedures, well, there are legal procedures where this is assessed. But there are also political, say you have a group of refugees, for instance, you have developments where after a while, you have the recognition that sexual identity could be a reason for asylum. This is a development. So there has been a negotiation in the sense that after coming up many times, people have maybe written scholarly papers and had political campaigns in favor. So that's a little bit what I mean by negotiations in this broader sense. But again, I think this is precisely where we need to pin the question: how does this represent refugees in any ways? Where are those who are most directly affected in those procedures? So I can only thank you for those two questions that are really to the point.
Thank you very much. Andrea, you would like to ask a question. You raised your hand. Would you like to ask? Please do. Thank you very much for being here. No, cannot hear you.
Okay, can you hear me now?
Yes, thank you very much.
Thank you so much. Thanks so much for that presentation to the author. Thanks for the organization for arranging this. Now, I was just wondering, and this is for the author as someone who, has done a lot of research on this and is engaged with the laws that exist, and I'm hoping potentially how the law can be changed to reflect actuality. So one of the things I've always been concerned about is the fact that economic refugees is not an actual category, where there are persons who are part of the large group of persons who are counted among those that migrate to other countries such as Canada. They're professionals like myself. And the main reason for them wanting to change location is lack of economic opportunities linked to their training and career path in their countries. I visited Haiti. I've done nonprofit work in Haiti and Jamaica, and I see where economic factors significantly impact and influence movement, even to neighboring Dominican Republic that share land borders with Haiti, and they were one country at one time, and there was an international issue about them wanting to send Haitians back, even those that were born there. And anyone in the forum can answer, because I imagine here we have persons who have done significant research, both from the academic and possibly civic society perspective. How far are we from the consideration of economic factors as a legitimate, driving factor that influences migration? And is there any potential at all for there to be some kind of, effort to move economic migration as a bona fide refugee category? Do you see it as anything that is even viable or legitimate? It has a legitimate potential. Thanks.
Yeah, that's a great question. Let me give several answers because I don't have one clear one. One is really, how could the law be open towards economic claims? And I think the closest we get in this direction is when we now have a lot of refugee protection happening over human rights protection. So I've spoken about the Geneva Refugee Convention, but very practically in Europe and elsewhere, human rights regimes are often the ones that are most dynamic in accommodating new claims. And we have, for instance, with the Cartagena Declaration that I mentioned briefly before, which is the non-binding declaration, but that's been incorporated in most Latin American states for the refugee definition. And then it mentions the violation of human rights. So I think this is one gateway, and we might find parallel formulations elsewhere on the level of regional or domestic law. And once we have the rather broad category of human rights violations, I think we can talk, and then of course that's a question of legal arguments, we can talk about the violation of social and economic rights as a ground for refugee status. And I think it's a very far away from where we are now. It's certainly far away for how case law has been in Europe, but so this would be one legal gateway. And then there's of course a question to which degree. I think this would probably require that there's really such a level of lack of economic perspectives or of denial of economic and social rights that migration seems kind of the only way out. So there's a whole, the whole range of questions then that follows, but this is one direction I would look into. Then just let me add two quick points. One is to say this whole distinction of refugees versus other migrants or other forms of migration can seem very artificial when we look at the world as it is right now. It's artificial in the sense that it kind of presupposes that there's always one causality for migrating. And very often it's not the case. You might be really in a difficult political regime, but at the same time looking for economic opportunities. And it's hard often to understand why it should be detrimental to your migration claim that you also want to build up something economically. That's often what's the case, that you better don't mention in your asylum interview that you also have a plan for a business, because this will ruin everything. So this said, I think we have to see how the legal distinctions that were once made have become, or have maybe been for a long time, a bit artificial to how the world works right now. At the same time, I often, well, I've said before this idea of the refugee concept as a block in the door, that I feel there would be a big loss to giving up this idea of an exceptional claim to protection altogether, because this might mean that states just assume full discretion in regulating migration. So rather than, even though it can seem very artificial today, it might be strategically better to work with those concepts as they exist, rather than giving up and saying, let's just talk about migration. So this is the second point. The third quick point is really to emphasize, I don't think refugee protection is the only category of migration justice. And that's very important, because often it's debated a bit like, well, there's the whole area of refugee claims, and that's where we're talking about justice, and everything else is just about opportunities and kind of utilitarian logic. And I don't think this is the case. I think we really need, and these compacts might be a step into this direction, we need a migration discussion that accommodates claims of justice more broadly and also is able to mix state perspective of opportunities of what migrants they are looking for with claims of why people want to move. So yeah, I hope this just gives some food, and I'd like to hear what you think. Yeah.
Thank you very much. I would like to raise two questions from the chat. The first one is, since you mentioned that one of the outlooks of the book is the future development of refugee law, what kind of challenges does the current COVID-19 crisis pose to the traditional understanding and governing of refugees, and how would that reflect in the future development of refugee policies? This is the first question. And the second question is, just to roll it up, the right to entry into a country is a sovereign national right. How can someone enter illegally and claim facilities and sustainability when he's not a citizen? He has no rights in that country without getting or government permission. So this is the second question.
Great, and I think they're to some extent related, because I'd say to the first question, so what are the challenges for refugee law under the current COVID situation? I think the COVID is really, in comparison, a smaller phase. I mean, we all don't know where this is going and how this will end, but I still see it as in the light of the very big challenge that refugee law is facing. This is sort of a minor theme that adds on top of it. But what it does very often is increasing where I see is a main challenge for refugee protection anyway, namely the very first access to territory, to protection. So states also in reaction to human rights adjudication, to human rights case law, that often has increased the rights regime once people are present on the territory. States have turned to trying to hinder this very first access, and very often now this is where we see the problems. This is also where we see really gaps of rights protection, and COVID has provided states in some cases with also an excuse to not have people get this very first entry where they have access then to an asylum procedure, etc. So I certainly think in that sense COVID has been a challenge. It has been a challenge, of course, in many ways, also in terms of accommodation, in terms of how to actually process. Of course, there is a level where this increases the bureaucratic challenges also, but I don't think this is something so fundamental as the other developments. And this links to the second question of how can one enter illegally. If I understand it right, it's a bit the question of how do we even get to the situation of making a claim as a refugee if the very entry is illegal. And I think the interesting thing is that in the Geneva Refugee Convention, there's already this principle of non-penalization. So the idea that a refugee should not be criminalized or penalized for crossing a border illegally. I think it's not such a new situation that there is a tension between an idea of legitimate entry, namely the refugee concept, and at the same time a rule of closed borders, or at least of strictly regulated borders, where people do not easily get a visa to search asylum. Or so this question of illegality, I think, has been around and also responded to legally.
Thank you. Just for two more questions, yes, Dr. Topor and Martin, and thank you very much. Lev, please.
Okay, so thank you, Dana. This was very interesting. I enjoyed your discussion on specifically on the tension between democracy and the need of people to get to safety. And I enjoyed your discussion on the debate whether it's a normative thing or a legal thing. And like you said, it actually is in the middle somewhere. and unfortunately, reality is right there in the middle, and at times one cannot decide and understand whether a case is actually a case of need and emergency or not. And I wanted to ask you, since you mentioned that the book was written or thought of before the European migration crisis, how do you foresee Europe, for example, if let's just imagine that some countries will leave the Geneva Convention in Europe and let's say in Canada and South America and so on, because countries, like the case we saw with America and Trump, they simply left international conventions, and this could be the case with the Geneva Convention if things will be worse in the future. So what do you say about that? I'm very interested to know what you have to say about this kind of scenario. Thank you.
Yeah, thank you. A bleak scenario, but let me start by saying that I think it would today require leaving a lot of conventions. So the thing is that really the Refugee Convention not only has the Geneva Refugee Convention for Europe, talking about Europe for the moment, being kind of translated and implemented on so many levels of EU law also. It's quoted, it's quoted, but also kind of translated in the provisions of the reception condition regulation, directive, on the level of asylum procedure. So on all those levels, there is also a reflection of, of course, all this is law that can be changed. So the first level is to say it's been implemented. The other is to say today the protection is so much backed up by human rights law that it might require those states wanting to leave also to leave all the Human Rights Convention, or it might, and actually that's where it gets bleak, because it's not completely unimaginable that there's also a change of understanding of where human rights can be interpreted in many ways. And there have been attempts of radically reducing the reach of human rights obligations. So this is one way how this backing up of refugee protection that currently still is very strong under Human Rights Convention could also kind of be withdrawn. But so with all this, of course, it is possible that this would happen, that states would radically reduce their legal commitment to refugee protection. And I think it is a horrible idea, because in all these regimes also there's a certain collective action problem that we see already now, that many things function when several states participate, and when some states withdraw, there's kind of a downward spiral that starts with many of the reception conditions, but also access to protection. And yeah, a world where states would more or less all, or many of, especially the British state, would withdraw from their commitment to refugee protection, I think would be one where not only inequality is cemented and there's a shutting of eyes against the suffering of people, but I think this would mean really an end of human rights altogether, because you cannot have an idea of fundamental rights but then completely look away from certain people depending on their nationality or depending on a border. So I think this question of refugee protection in that sense is really fundamental to any legal universalism that we have. And yeah, that's the very bleak future that I hope we will not get to know.
Thank you very much. Martin, last question, please.
Yes, thank you very much, first of all, for the discussion. It was very interesting for me. And my question is, you mentioned, I think, that refugee law, or the law, it's already fairly good most of the time. So you said that you wouldn't criticize it that easily. So, but to some extent, of course, it needs to be changed in order to let the refugees be represented in the government and in the state. So to which extent the law needs to be changed, and how can this can be done in a quick manner in order to have a strong impact in the whole world? Thank you.
That's a great last question. I think the best changes that could be implemented on a legal level to improve political participation of refugees would, on first level, be in the states to extend those flexible mechanisms of participation. So communal voting rights, special bodies of representation, and also really all the gateways to engage in political activities. So extending freedom of assembly and freedom of association. This would be on the state level. And then I really think that there is great potential for the international level, that thinking about this structural lack of refugee representation, it would be possible in all the structures that exist already to have maybe also a voluntary mechanism for refugee participation that enables also to just gather knowledge that people bring. And I think it could not easily live up to democratic mechanisms as we think of them from state institutions, where there's this principle of one person, one vote, where there's a very far-reaching assumption that there not only must be voice, but equal influence. I think that would be very hard to achieve, but what would be possible would certainly be to extend just the ways of having voices enter these decision-making processes. And I think also new technologies, new communication possibilities could be a gateway for making this pretty easy. That's the direction I would look into.
Great, but please another question, because the audience here are putting me a lot of pressure. So I want to give the floor for Rufat, good friend, and please, Rufat.
Thank you so much, dear Dana. Thank you for a very interesting presentation, and please accept my sincere congratulations with the publication of your book. So I have two short questions. The first one, as I understand in the first chapter, when you're talking about who is a refugee, did you do like a comparative analysis who is being accepted by definition refugee in different countries, right? Let's say in America, in Europe, and in other countries. And the second question is like, I don't like this word, but you know, being a refugee in some societies is being accepted like a stigma. So did you study, or I don't know, did you tackle this problem in your study, the problems of integration of refugees into the host society? Thank you so much.
Yeah, excellent. So first, very brief answer. What have I looked at in this, how people are accepted as refugees? I've very much limited myself to looking at the level of the laws. So I've not studied how these laws are applied in practice. To say, for instance, of course, you can look at quota of who is accepted, but also more, I mean, you really would have to go into the decision-making bodies to see how do they actually apply this? Do they maybe silently exclude it? No, I've stayed on the level of the written laws, which of course is only a very rough lens. And then your second question of how the refugee concept can be looked at as or sometimes be conceived as a stigma. I think that's really interesting because it points out that there are two moments where, or two phases where the refugee concept is in a total different opposition. Initially, it's a concept that allows entry. So it's kind of the opposition of being a refugee or not being a refugee, and this will decide whether you can enter or not. This is where it's desirable to be a refugee, so to speak. And then there's a second phase where the opposition is rather between being a refugee and being a citizen, or being a permanent resident, but more accepted to permanently stay. And this is, of course, where being a refugee is no longer desirable. And the idea of the convention would be that there is a dynamic between those phases. And very often the problem comes when this dynamic is interrupted, when you kind of only stay, when there's no end to refugee status. This is what happens with humanitarian government often, that people are refugees for generations. And I think in this case, we really need to see how the refugee concept should only be a temporary status. And it's absolutely crucial that people can move out of it, because it means also deprivation of full political membership. If you can never integrate and become and receive, integration often has all these assumptions about culture, but really primarily it's also about having some status as a political member of the community. And I think this is really crucial.
Great. Thank you very much. Thank you very much. I think that the subject of our interest of migration in globally, but especially refugees, it's a thing that it's an issue that influence countries and nations, and it has a huge effect for nowadays. And speaking about generation on generation, that the effect will take place. And I think the book, reading the book and hearing you, it's just reviving the mind, the thoughts. And I'm very thankful for your presentation and for your presence here. I just wrote myself lots of notes, just to go through, to continue reading, and it really made me and us to think about this phenomenon, which is old as humanity, but nowadays in the last years, especially from the Arab Spring, I think the influence of that is much impacting the EU, especially, and it's raised a lot of questions and issues concerning that. And I think your book in this issue is an eye opener and mind opener for many issues concerning that. And thank you very much. Just before my last conclusion, I would like to give the floor to my friend, the founder and the chairman of the IIMSR, Colonel Goren. He wanted to say some ending notes. So Amir, please.
Yes, of course. Thank you very much, Dr. Schmalz, so much for your fascinating lecture. And we hope to see you soon again with us. It's very interesting. Thank you very much again.
Really, for having me. This was a great pleasure and such an engaging. I'm taking away also many notes, so I feel while there has been a book, and it's very strange to have a printed moment of your thoughts, because I feel this is still very ongoing as a reflection process.
Absolutely. And the questions keep on going. We concluded, but the questions keep on going. So if you would like after that to respond to people in email or something, we'll be happy. I think I will type my email address in the chat, and I would be very happy if you want to continue and send me an email. I'll be happy to. Great. So please do. You have something like 6 or 7 emails, so one of them will be adequate.
Thank you.
Thank you very much. So really thank you. I would like to thank you in behalf of the IIMSR, on behalf of everyone here that took part in this interesting and very insightful presentation. I think that the insight you gave, the knowledge you showed is very valuable, and I think it will raise more questions and more issues regarding that, especially for us as an institute that focusing in migration and in the questions of migration and the impact of migration on many issues, from law, security, health, and many other. And it's very interesting. It was very interesting for us, and for you participants, dear participants. We absolutely hope that this event contributed for you for a better understanding of the topic. And thank you very much for attending this event organized by the IIMSR. And of course, you can continue follow us on our events, on our papers, and our publications in our social media channels, at the YouTube, at our website, iiimsr.eu. And thank you very much for being here. Thank you very much, Dana. Thank you very much to the team. Thank you very much, and have a great weekend. Thank you very much.
Thank you.
Bye-bye.
Bye.
Thank you.